Constitution, as the language of Article 368 is plain and unambiguous. It is not possible to read therein a limitation on the power of Parliament to amend the provisions of Part 3 of the Constitution so as to abridge or take away fundamental rights. It is also not permissible in the face of the plain language of Article 368 to ascertain by 3(9) process akin to speculation the supposed intention of the Constitution makers. The words are plain and free from any ambiguity. The Constitution makers should be taken to have incorporated their intention in those words. Collector of Customs, Baroda v. Dig v. Jinghi, Spinning Weaven F. Mill J. Lod, 1862, LSCR 896, referred to pp. Citing to 671. The argument that an amendment of Part 3 is possible by making a law for convening a constituent assembly or for holding a referendum cannot be accepted. If Parliament by a 2/3 majority in each House and by following the procedure laid down in Article 368 cannot 2/3 majority in each House, would it be permissible for the same Parliament to enact legislation under Entry 97 List I of the 7th Schedule by simple S2 Supreme Court Reports, 1973, Sup. C. 11. Majority for creating a constituent assembly in order to take away or abridge fundamental rights. A body created by Parliament cannot have a power greater than those vested in the Parliament. If something is impermissible, it would continue to be so, even though 2 steps are taken instead of 1 for bringing about the result which is not permitted. Again, the argument that provisions C could be made for referendum is equally facile. Our own institution makes and rejected the method of referendum. In a country odwait CTC there are religious and linguistic minorities, it was not considered a proper method of considering vital issues. Thus apart, it is not permissible to resort to the method of referendum unless there be a constitutional provision for such a course in the amendment provision. The selection of the method of amendment having been made by the Constituent Assembly, it is not for the court to express preference for another method of amendment. There is no warrant for the proposition that since the amendments under Article 368 are brought about by the prescribed 100th majority of the 2 Houses of Parliament, and in certain cases are ratified by the state legislatures, and since the amendments are not brought about through referendum or passed in a convention, the power of amendment under Article 368 is on that account subject to limitation. 671078, GTTGE Shawkees v. Hervey C. Smith, 64L ed. 871, FAO'd LSL and J. v. Mitchell, 64L ed. 946, and United States v. Sprague, 282 U.S. 7016 referred to. Parliament cannot be denied the power to amend the Constitution as a takeaway or abridge the fundamental rights by complying with the procedure of Article 368 because of any supposed fear or possibility, or the abuse of power. That power may be ABWCD furnishes no ground for denial of its existence. The fact that a prescribed majority of the people's representatives is required for bringing about the amendment is itself a guarantee that the power would not be abused. The best safeguard against the abuse or extravagant use of power is public opinion, and not a fetter on the right of people's RCPRC says candidates to change the Constitution by following the procedure laid down in the Constitution itself. For 17 years from 1950 till 1967 when Go Aknath case was decided, the accepted proposition was that Parliament had the power 1D amend Part I of the C Constitution so as to take away or abridge fundamental rights. Despite the possession of that power, no attempt was made by Parliament to tie. If it was not done in the past, why should it be assumed that the majority of members of Parliament in future would acquire sudden aversion and dislike for these values? Then, is a vital distinction between vesting of power, the exercise of the power and the manner of its exercise. What is in issue is droit cliquer. On a true construction of Article 368, Parliament has or has not the power to amend the Constitution so as to take away or abridge fundamental rights. The answer should be in the affirmative as long as the basic structure of the Constitution is retained. 678 to 682, Providence Bank, Balfius Billings, 29 U.S. 514, OHN Ella Rapier, ER Part, is U.S. 3 Bank of Toronto and Lambay, 12 AC, 575 Mauri Kansu on Texas Railway Kavme, 194 U.S. 267, and Pharisee D2. The power to amend under Article 368 docs not include